Hopefully it'll work. I think it maybe was because it was unplugged. Okay, good afternoon, ladies and gentlemen. Have your attention, please. All quiet, please. Thank you. Go ahead and take your notes out. We're going to continue on with the courts, get into all of the, some of the stuff is pretty interesting. Some of the stuff is sort of like preliminary and foundational, so that we have a much better basis to get into some really hot and heavy stuff, like actual civil rights cases, like gun control, stuff like that. So that's all setting up. The civil rights stuff is like the heart of the matter, but there's some really, really interesting things going on even prior to that time. Yes? Yeah, so for you guys, pretty much every Tuesday for the next month or so, bing, 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 quizzes. Yeah, little quizzes, so yeah, 4 of them, exactly. Yeah, so come in prepared on those ones. It seems like they're mostly true-false. I might have some matching sections in there. Okay, we'll do those like right at the beginning of the Tuesday class and then get right back into the notes where we're at.
We do essays.
No, because here's the deal. I found out very quickly. Didn't happen. I think it happened before I gave you guys a test. Because when we went to like quarantine, I was just finishing up actually this unit with the 10th grade class, and I'm like, oh well, I can put together a test and so forth. It came back. It was really disheartening. Because I didn't do it very well, setting it up and so forth, but it was really, really easy for people to cheat like but yeah, it was bad. So like one particular, like the second day class, more than half of them had like perfect scores. I'm like, that's weird on a Mr. Hansen test, because it's a pretty challenging test with all the case names and everything like that. And so I quickly figured out that, yeah, I can't figure out how to do it. I know Miss Moreau and maybe some of the other teachers tried to do like some of that and like had parents, proctors, and so forth. I'm like, no, right? Unless I can be there to proctor and so forth. Yeah, and so it kind of turned out a little bit easier. But I mean, the bigger challenge was actually trying to, connect as much through a video screen, which is a little harder, as opposed to actually being here. The experience of learning, right? How many of you guys prefer face-to-face learning as opposed to like Zoom learning? How many of you guys prefer Zoom learning? Oh, there you go. Well, hopefully by the time you guys are like doing college and everything will be all opened up, so you don't have to do that if you don't really want to. Yeah, you like the online? There's perks. Yeah, you don't have to get in a car and drive a long way. Exactly. Oh no, trust me, I know. Yeah, you're like, how many of you guys are missing having some sort of like not rushed time at least every other day? Yeah, okay. So, I mean, there you go. And actually, I did like one of the things, and I hope you guys feel comfortable enough as we move forward with this, because in the separate 2 groups that I did have on the Blue Day and Green Day and so forth, we had some really good dynamic educational interaction and so forth. And that's one of the benefits of having smaller class sizes, is a little bit more comfort level so that you can feel like you can interact a little bit more and so forth. And I like it too, because then I can call on you more often. But that's no problem, right, Max? Yeah. Right, Trey? Yeah. Because, I mean, it's like you want to draw out all those various different opinions and so forth. Okay? Yeah. No. Unless you get specific permission from Mrs. Anderson. It's a food. No, I'm not going to get into it. It's not my directive. If it were totally up to me, I'd be like, fine, yeah, whatever. You got a mask on. But I could see that, make the argument, see if you can get a permission and so forth, approval. But if you want to take a granola bar and ground it up into like some kind of a liquid form, that's liquid. And I think liquids are still okay. You can make a granola smoothie. I don't know. No, I'm serious. I mean, advocate for it. I think that would probably be okay. But I don't want to be in a position where admin comes in the room, they see you sucking on a sucker, and you're like, pink slip, Mr. Hansen, bye, Yeah. Yeah, I'm not going to put my job on the line for your sucker. I'm not a sucker for your sucker. But if you get permission for that, that's awesome. Okay? That was an easy one. Yeah, it worked. Okay. All right. The law. Actually, I'm kind of curious. How many of you guys, raise your hand, I'm just curious. It's okay, not putting you on the spot or anything. How many of you guys are like contemplating potentially, possibly some kind of a future that involves like law? Actually, wow, three, wow, okay. Yeah. So, I mean, if you ever did have questions at any point in time and so forth, you can ask that. Obviously, for a law career, you have to pass the bar exam. Bar, B-A-R, bar exam. It's a test that is taken, and if you pass it, then you can practice law in that state. And then it gets complicated as far as like other states and so forth. But generally, you need to pass at least one bar exam if you're going to practice in that state. Before that, you need to go to law school for like 3 years. Okay, I went to the University of Idaho. Before that, you need to get an undergraduate degree, which takes about 4 years. Okay, before that, you finish high school. No, it's a little bit different. Yeah. Each exam is going to have, there's going to be some peculiarities so that you need to know some of the interesting things about, like, in Idaho, like Idaho law. Community property. We're a community property state. And you're like, what? Isn't that like a place that you go on like a Monopoly board game? No, it's not. It's actually really cool. Community property is a really cool, innovative thing that protects the rights of women over long periods of time in the history of the state. If you marry someone, what is earned in that marriage is equal. There is a recognition that somebody who holds a position that earns money versus somebody who holds a position like looking after the kids and the household and so forth are both equal to the success of that. So you're like, well, why is that relevant? Well, if you get a divorce, the general view is that the community property, that which has been collected and earned over the time during the marriage, is going to be roughly equally separated. Does that make sense? As opposed to the one who earns all the salary gets to, keep all the stuff. That's an Idaho thing, and they actually have it in a number of states. Not all states do, but that's just an example of how that would show up on an Idaho bar exam, but it might not show up on something in another state. It's okay. You guys got all kinds of really interesting questions, and I entertain those, and sometimes it's right smack dab on point. Sometimes we can delay it a little bit, but it shows a level of interest, and literally there's so many different areas that this can go through. But let's just jump right into it. On the document that you have in front of you, does anyone have any questions on trial courts, magistrate, and district? Oh, magistrate, district. I'll make that clear. Because if I write it on there, you're like, what's the difference between a magistrate and district court? Are you ready? Here's the answer. Magistrate court is lower than the district court. Okay. Magistrate court is lower than district court. A district court is kind of interesting because a district court can handle trials. Right? So there's a trial. Magistrate courts handle lots of trials. District court handles like serious trials. We're like, well, what's the difference then? Well, a district court can also handle, you ready for this? Because this is going to be something we'll be talking about. If you lose at a trial, I think we hinted at this a little bit, you can appeal to a higher court. And we'll develop this fully as we go through today. Whatever that higher court is referred to in general sense as an appellate court. That's who you appeal up to. Okay? So a magistrate court in Idaho is the lowest court. If you lost a case in a magistrate court, you could appeal it up to the next highest level, which is a district court. Oh, okay. As it turns out, district courts got to do a little bit of both. They got to do some of the appeals. I'm appealing because the judge made a mistake and allowed this evidence in. I'm appealing because there was jury misconduct. I'm appealing because whatever kinds of things that went on in the trial. Hang on just a sec. You appeal up to the next level. Guess what? If you lose on that next level, is that it? No, you can appeal up to the next level. What's the highest level appeal you could have potentially in this country? The United States Supreme Court, yeah. And that's where we're going to be looking, because when the United States Supreme Court rules on something, that's going to be like the most important potential ruling. Does that make sense? Okay, here.
appeal to a higher court, do they just simply go over what was already stated in the first trial, or do they have a retrial?
If they say there was a mistake, a wrong ruling or something in the original trial, they could send it back for a retrial with instructions to do it the right way. As in, don't make that mistake again. Okay? Sometimes it's going to be, when we get to appeals court, sometimes it's not like what happened in the trial. It's like the law that's being enforced here, it's like unconstitutional. I mean, who gets to decide that? Ultimately, it could be the Supreme Court's. Their opinion ultimately is the most important. Yeah.
So is there any way to stop, like, cases that go to the Supreme Court?
Yeah, I mean, the Supreme Court doesn't have to take cases. You'll see this in your notes when we get to it. There's going to be thousands and thousands of appeals where they'll be like, Supreme Court, take our case, take our case. And they'll be like, we'll pick about 100 of the most important ones that are, kind of tricky. Because, I mean, there's 9 people, and some of them are pretty old. They only have so many staff. They can only handle so many cases. I think we covered this. Was it in here or was it the other class? If somebody brought a really stupid case, because we saw this, and it was like, can you sue for anything? The answer quickly is yes. Is there any negative consequences on you if you sue for stupid things, as you pointed out? Yes, because if you bring a lawsuit, the other person, you are the plaintiff, right? You understand that? You're the plaintiff. You're bringing the lawsuit. The other person is called what? The defendant. Good. Okay. Do they have a different name if they're in a civil versus a criminal case? No, they're still called the defendant. Okay. Criminal defendant could end up having to be in jail. Civil defendant might have to pay us some money. So let's say somebody brought, as a plaintiff, a really stupid lawsuit against you. You have to defend it. You're going to have to go talk to a lawyer. You're going to have to pay a lawyer to defend it. And then you're going to go to the judge. You're going to, Your Honor, this is the stupidest case ever. This thing could never get anywhere. This is ridiculous. I would like you to do 2 things, Your Honor. 1, dismiss this case. Make it go away. That'd be nice. 2, make them, the plaintiff, the people who brought the lawsuit, pay for my attorney's fees. Got that? Well, no, I mean, you don't even have to sue them right back. I mean, you could countersue, as in, like, you're suing, saying that I caused you harm, and I'm like, no, you're the one that caused me harm. That's called a countersuit, right? That's the sue them right back part. But if it's just a stupid lawsuit, you're like, Your Honor, dismiss this case with prejudice. You let them never bring it back again. And award me attorney fees. Make them pay the money that I had to go through. Does that make sense? Yeah, we do that a bit in the United States. They do it a lot in Britain, which really keeps the number of cases down. But in the United States, if you've never heard this before, we're very litigious. It's a fancy word that basically means we like to sue a lot. I'm walking along the street. Ow! Who can I sue? Yeah, it's like, I'm not going to talk to you and get it all sorted out. Talk to my lawyer. You're like, whatever. Jeez. America. I mean, we got a really good court system, but sometimes people are like, well, is the court system the only place that things can get solved? I don't know. I mean, we have some of our popular TV shows. People's Court. Take them to People's Court. Yeah. What? Exactly. I mean, those are real. Mm-hmm. All right. So we got magistrate, district court. Any questions about judge, jury? That was the second one on there. Pretty clear on that? Okay. Who officiates the case? The judge. What does the jury do? Decides. Yeah, they decide what the facts are. The facts support that this person did it, or that this person, beyond a reasonable doubt, is criminally responsible, is guilty. Plaintiff, in criminal cases, is called the prosecution. I think that's straightforward. Difference between criminal and civil. Burden of proof, I think we talked about that. Jurisdiction, there's all kinds of different questions about jurisdiction. And I mean, literally, it's almost like if the court can hear the case, they may hear the case. If they can't hear the case, they will not. If they don't have jurisdiction. It's kind of like, I don't know, if you walked into a house and you're like, my sibling did this and this and this and this, and then the person looks at you and go, you're not my children. I don't have jurisdiction over this case. And then you look around and you're like, oh, that's weird. Sorry about that, neighbor. Who has jurisdiction over matters between you and the sibling? Yeah, your parents, yeah. You. Wow, okay. Yeah, I am the court. I am the law. Actually, I'm curious. Who is the highest court in your house? Raise your hand if it is singularly held by mom. Raise your hand if it is singularly held by dad. Raise your hand if it is a shared power, mom and dad. All right, so we got 2 on the court. Raise your hand if there's any other configuration of the highest court in your household. I'm curious about this one. The dog, really? Rough justice, that's what it's called. Yeah. No other ones? The cat? Yes? That you should be. Give this man some robes. Give him like a court. Give him a gavel. Woo! Here come the judge. Yes. How many of you guys believe that Caden is the highest legal authority in his household? Who is?
My parents have believed that they include me in decisions.
Oh, I see. So you're part of the highest court. How many of you guys would say that you're part of the highest court? How many of you guys would say that you're consulted at least? So your opinion is, that's good, right? Because they're raising you up, right? Because ultimately you're going to be an adult someday and you're going to be responsible for making important decisions like the health care and assistance of your needy parents. Oh. Oh. Yeah, yeah. A nice retirement home. Nice retirement home. With good food and entertainment. Yeah, and I don't know, really good streaming services on the television system. All right, let's deal with this one. This is the first case you're going to need to know of many, many different cases, Mcculloch versus Maryland. Let's deal with this one. It's kind of it's important for a number of different reasons because it's an important case that the United States Supreme Court decided early on, and we're going to see this early on when the United States Supreme Court decides things. It's like, whoa, those guys are really like staking out who's in charge. And they will. They're like, hey, we get to interpret. This is 1819. 1819, the United States has only been around for like, 20, 30 years, at least under our Constitution, about 30 years. And there's a dispute, okay? It is a dispute between the United States government and the state of Maryland, okay? And this is going to be one of those lovely supremacy clause type disputes, okay? The United States government, Congress, this is actually, for those of you guys who are fans of Hamilton, Hamilton was a big proponent of a strong national government with the ability to have a really good financial system, including, write it down, a national bank. We don't have that now, but Hamilton was able to get that through Congress, signed by the president. There it is, a national bank for the country. All right? Now, some parts of the country didn't like that, including Maryland. They basically passed a law that would tax the United States National Bank. So you can see where this is going. Yeah, you're going to have a fight, and it's going to be handled in the courts, and the Supreme Court will say that is going to make its way to us, and we're going to decide it because we interpret what is the highest law in the country. Constitution of Maryland? Laws passed by Maryland? The Constitution of the United States. That one. And the Constitution of the United States says that, as interpreted by the Supreme Court, that Congress has the authority to collect taxes and to establish like regulate interstate commerce and so forth. Anyway, they look basically up there and says, it is necessary and proper, it's okay for Congress to be able to do that. If you don't like it, get it repealed. And actually, I want to say like within 10 years or 20 years or so after that, they did get rid of the national bank. And then we came back with something even bigger, which is the Federal Reserve, but I'll save that for another day. Maryland tried to get it stopped. Could Maryland stop what the national government was doing? No. Okay? A state doesn't have jurisdiction to stop what a national government is doing, as long as that national government is doing it properly. Is that an exciting case? Not that much. Does it give you a sense early on that the Supreme Court gets to decide finally what the really big questions are that are in dispute? Yeah. Now, it's always a very interesting question because, I mean, somebody, I think it was you asking kind of almost facetiously, can they just like decide whatever they feel like it? Kind of, sort of, yeah, although they are going to try to be very careful because if the country ever decided the Supreme Court was like way out of bounds, that would be problematic. And it has happened sometimes, okay? We'll get into that a little bit more as we get into the actual civil rights cases, but I think that pretty much covers the Mcculloch versus Maryland. You cannot impair a federal law or a federal program if the federal government is justified under the Constitution in doing so. A different tack. Judges, how are they chosen? Now, one thing you need to keep in mind here is we've got a federal system, United States judges, all the way up to what's the highest court in the United States federal judicial system? The U.S. Supreme Court. Make sure you also identify that states have their court systems handling their laws. Got it? And they do things kind of an interesting way. Each state can set it up. I don't know how up-to-date this map is, but you basically kind of have a sort of a choice of two different kinds of things. You can have an election system whereby judges are elected, or you can have an appointment system whereby they are appointed and they don't necessarily stand for election for the voters. By the way, let's make a little note of this right now. That's a state thing right here that we're going to get to. What about the federal government, the United States government? Are judges, Supreme Court, and the other ones, are they elected? Make sure you write this down very clearly. They are not elected. How do they get their jobs? They're appointed. And how long are they on there for? For life. That's the way it's set up in the Constitution. That's about as hands-off as you can get. If you want to have some influence on who the judges are, the people you're going to have to influence are the president, because the president gets to appoint the vacancies, and then the Senate, because they get to approve or disapprove.
Are there any courts between the federal and the Supreme Court?
What we have is a federal system, and I'll spell this out a little bit more today, so you'll have hopefully a much clearer understanding. We have a federal court system. We'll get into the details of that. The one that you do know is that the highest court of the federal court system is the U.S. Supreme Court. And then, how many state court systems do we have in this country? 50. And typically, what is the name of the highest court in that particular state? State Supreme Court. So in Idaho, the highest court in the Idaho court system is the Idaho Supreme Court. That's where I went to work after I finished law school for 2 years. Not as a judge, not as a justice, but as one of the two clerks doing research and writing and so forth to help that justice. Okay? Question. If you are at the Idaho Supreme Court and you've got a case there and you lose, and it has to do with like some U.S. constitutional right, could you appeal from the highest state court, in this case Idaho, up to the U.S. Supreme Court? Yes.
No, if they're a state court, what about for federal?
They also have court systems there. Very good. Okay. Which do you suppose is going to have more public input on who the judges are? An election system or appointment system? Election. Yeah, you can put that down. And if you are a judge, which system are you going to feel like I really need to pay attention to what public opinion is, as opposed to, I don't know, how I read the law and how it's supposed to be? Not that they're entirely separate, but which do you suppose is going to allow for a little bit more like, oh, this is what the people are saying? Election, yeah, because they can throw you out of office. If you're appointed, it's not going to necessarily work that way. Okay, question? It varies from state to state. Here's the answer. In Idaho, you can write this down. Idaho has, it's a mixture actually. It's an election system, but if somebody leaves before that term is up, and so an election system for a term, I think like the Idaho Supreme Court, they're like terms of 4 years, maybe 6 years. If somebody leaves before that's over, then an appointment will take place. And that actually happens a lot. Although sometimes you'll have somebody going, I'm not going to leave until the end of my term, and then I'm just going to see what the voters come up with. So it could end up being either way. In Idaho, if there is a vacancy because somebody resigned or died, it'll be the governor who gets to appoint. Okay? In some states, you can write this down. Their election system in some states is non-partisan. Anybody have any idea what the word non-partisan means? Yes? Very good. So if you're running on a non-partisan ballot for judge, what will be your political party? None. Partisan. Partisan. Okay? Idaho, you can make a little note of this. Idaho's judge elections are non-partisan. Some other states are partisan. So you literally could have somebody running for, I don't know, Kentucky Supreme Court as a Republican or as a Democrat. Do you think that might help you somewhat in any particular state? What party affiliation do you suppose is going to help you the most if you're running statewide in the state of Idaho? Of course it is. And in fact, it was weird because I remember there was this one election for Idaho Supreme Court. And of course you're running, and the guy who's running against the incumbent, the person who was there already, was pointing out to people that when this person was a lawyer before she became a judge, she contributed a lot to the Democratic Party. Why would they point that out? Because that would be potentially something that could help them. They're trying to sort of like buddy up closer to the Republican Party because that's a stronger party affiliation in the state of Idaho. We've not had a statewide Democrat elected or congressional Democrat elected, I want to say in the last 10 years at least. Okay, the Republican Party is very, very strong. It was a little bit closer once upon a time, but it's very, very strong Republican. So they were kind of like taking a nonpartisan race and trying to go nudge, nudge, hint, hint, by the way, you know, I'm a little bit more. And it worked. That guy won. It actually worked. The reason why they try and stay away from it is because they're trying to sort of make it a little bit more judicial. Write this down. In the courts, the hope, sort of, is for the judges to be all like, I'm just following the law. I'm not really looking at public opinion. I mean, who's supposed to look at public opinion? Like, legislators, Congress, the president, governors. I mean, because they are getting elected. These judges are like, oh no, we're not political. We're not like, we're just interpreting the law. Right. When you look at some of these cases and so forth, you can be like, that's an interesting way you've just interpreted the law. I really disagree with it. I'm like, well, you know, I guess we're just going to have a legal disagreement and so forth. Yes, but which law is going to be enforced? Well, I'm in the majority on the Supreme Court, so I guess my opinion is, you'll see as we go through this, judicial opinions and so forth can ultimately become very political. Okay? When you were talking about some things like Second Amendment rights or abortion rights, things like that, those are very political issues. But the people who have the most important opinion about them are members of the Supreme Court. Okay? Because they're also constitutional issues. All right, so we got an appointment system, election system. It varies state to state, just like anything else. You guys have discovered this, I think. That was one educational opportunity during the whole COVID thing. Does every state run their COVID thing the same way? Heck no. And actually, I'm kind of glad, like in Idaho, it's worked out pretty well, I think. I mean, at least just as far as some components. Vaccinations are coming out, and I'm not saying it's all perfect and everything. We're like, really? On the vaccination part, I like the fact that if you want to get a vaccination in Idaho, it seems like those are coming on quicker than in some other states. So I'm giving that as an example. I'm not giving an entire evaluation. You're like, MK's like, no, I don't think so. What, do you think there's a state that's done a better job? There's a lot of different opinions, because different states have done different things because they have the authority over that particular thing. Even if the president wanted to, I mean, President Biden gets on and President Trump before that are like, states should do this or should do that and whatever, and you're like, well, who makes the decision over like lockdowns or not lockdowns or vaccine programs and so forth? A lot of it's going to be state authority. And this is another example. states determine how their own state court systems are set up. Okay? All right. Appellate court. Okay? As I mentioned, appellate courts are any court that takes an appeal from a lower court. And we've got various different levels of a court. Here's what you're going to see in an appellate court. I've got the visual here. Take a look at the visual. You're going to have an attorney arguing to either one judge, or it could be 3 or 5, or even how many is on the United States Supreme Court? 9. Very good. You're arguing to them what the law is, what the law should be, whether or not the law was followed properly in the trial, whether or not the law that was passed by Congress or the states is actually constitutional. It's lots of argument stuff. Now notice what's missing in an appellate court. No jury, no witnesses. That's for the trial court. Got that? That's one of the biggest differences. Okay? You don't need the jury. You don't even need the client there. And if the client wants to be there, that's fine. But essentially, it's like it's the lawyers. They're in the room. They talk to the judges. Now, it's in public when they talk to the judges, but I'll tell you what. You know what the judges do after they listen to the arguments there? They go back into a private room, and they have a discussion. And then they start working on reaching a decision. Could take a while. Could take several months. And it's all done hush-hush. Write that down. It's all done hush-hush. When do we find out what the decision of the appellate court is? When they announce it. I mean, seriously. So when I worked at the Idaho Supreme Court, there were 5 justices. They each had 2 clerks. I was a clerk for one of the justices, the Chief Justice at the time. And we would help our justice figure out where they're coming from and so forth. And think of it this way. If there's 5 justices, how many justices do you need to agree to have a decision in the case? Exactly, a majority. It was really interesting because in the Idaho Supreme Court, I don't know if it's still there, but when I was there, in the room where they would get, the 5 of them, after they would hear the oral arguments and read through the written briefs, you can write that down. Oral arguments, where they make oral arguments and they answer questions from the judges. Previous to that time, they've written briefs, basically written explanations as to why they think the judges should rule in their favor. After they submitted all that, the judges go back in this room. There was a dartboard in the room of meeting for the Idaho Supreme Court, and it was a different kind of a dartboard. They made it an adjustment. So depending on where you threw your dart, it might land on death, or reversed, or lose. I don't know. They changed it all up like that. I mean, the joke was, is that how they made their decisions? They just sort of, I don't know, what should we do? I guess that person's going to hang. Oh, well, you know. No, I mean, it was a joke, yes.
So, when courts are, do they cap judge amounts at an odd number?
It's a good idea to do that. It doesn't always happen, but it's a good idea. You tell me why.
Why?
Yeah.
So you can have a majority.
Exactly. So you don't get like a tie. Because when they do have, sometimes like a Supreme Court, you'll have a justice die. They're like, well, let's see if we can get this thing done. And you end up with like a 4-4 tie. Whatever the previous decision was is the one that holds. So tie goes to the winner on the lower case. So it's kind of messy that way.
So they don't write that down. They just do an odd number.
No, they don't. But the people, who determines actually how many justices are going to be on the Supreme Court? Congress. They created the positions. The original Supreme Court had 3. I think they bumped it up to 5. I don't know that it's ever been more than 9, maybe 11, but it's been a long time. It's been 9. Okay? It makes sense to be an odd number because that way you get a decision. Or at least a decision everyone can look at and go, mm-hmm. Yeah, I mean, it's like in the Senate, 50-50. You need to have somebody break the tie because it sucks to have a tie. Who gets to break the tie? We've already determined that, the vice president, yeah. But I mean, like, I don't know, who breaks a tie if it's like, if you're in a family and it's going to be up to the kids to vote, and it's a tie. The dog, right? Well, who interprets the dog's opinion? Whoever's holding it's like whatever. Yeah. Okay. So, very, very important. This is occurring behind closed doors. Okay? Some verbiage. All right, this is kind of boring, but nevertheless, you still need to know this. Appellant versus respondent. What? I thought it was plaintiff versus defendant. Well, it is. Well, then what is this appellant versus respondent? Well, you get a new name when an appeal takes place. And in the initial trial, the person bringing the charge or bringing the lawsuit is called the, thank you, the person on the receiving end is called the, okay? The new name on appeal is based on whether you won or lost. If you lost and you want a different decision from the appellate court, you bring your appeal and you're known as the, very good, the appellant. So what do we call the winner? The respondent. That's it. So sometimes you'll see there, like if the plaintiff won in the lower case, that person is referred to as the plaintiff-respondent. And the defendant is referred to as the defendant/appellant. Whatever. Sometimes neither side is completely happy and they both appeal for different reasons. And it's just like, whatever. We'll just call this versus this. And that's why in all these Supreme Court cases and these important ones, the law is known as the name of the case. So when I say Roe v. Wade, what are we talking about? Aquatic transportation? No, what are we talking about? We're talking about the Supreme Court interpretation of the Constitution with respect to females who are pregnant who want to have abortions. Oh, that! Okay. When we talk about, you can use the fancy term like the District of Columbia versus Heller, or if you just want to say the Heller case, what are we talking about? Did we talk about that one before a little bit? The Heller case. What's the Heller case say? An individual has a right to have a gun to a certain degree, and the state can't just like, willy-nilly take it away from them. Okay? Does that make sense? It's kind of boring, but whatever. You got to have the names on there, so it does help sort of like know what your name is. What would you rather be, the appellant or the respondent? What would you rather be, the winner in the Supreme Court final decision or the loser all the way below? The winner in the final case. Because the winner is the winner.
I feel like you were trying to say two different things, but it sounded like you said the same.
Are you okay with losing in the trial court?
Yeah.
Are you okay with losing in the next appellate court? Are you okay with losing in the next appellate court? As long as what? That's it. As long as you win the United States Supreme Court. Especially if it's interpreting the Constitution. Because how hard is it to like just change the Constitution? Really? Really? What does it take? Is it really? What does it take? Chris, listen very carefully because you're going to check and see if this is accurate. What does it take to amend the Constitution? Correct? Correct. Good. And how often has that happened in our country's history? 27 times. Twice. Yeah. Did you say twice? Was that you?
It was Ivan.
Oh, it was Ivan. Oh. You need to contact Ivan and make sure that he's not feeling bad because he said twice, because that's just ridiculous. Yes? Oh, you had your hand up. No? Okay, here we go. Here is a nice visual to describe something that I've already talked about. There we go. Here is like the state court system. This would be actually kind of like Idaho's one. We have state trial courts, magistrate, and district. And district sometimes can be an appellate court. And then we actually have an intermediate court of appeals. Ours is called the Idaho Court of Appeals. The one that's just above the district court level is called the Idaho Court of Appeals. I don't know. They just stick them on different sides. I don't know. I didn't do the color origination. I just I just Googled and looked for a slide that might actually kind of sort of work. Sometimes they're okay. Sometimes they're like, whatever. So, in fact, do I have that? Yeah. There's the highest one in Idaho. The Idaho Supreme Court. If you know that, you're good to go. The highest court in the state of Idaho is the Idaho Supreme Court. 5 justices. The one just below that is the Idaho Court of Appeals, 3. That's how we do it. And then there's lots and lots of district courts strewn throughout Idaho. They're handling all kinds of cases and so forth. And so if you appeal up from that, you can go up to the Idaho Court of Appeals, and from there, the Idaho Supreme Court. And then where does it go from the Idaho Supreme Court, if possible, maybe? The United States Supreme Court, which is essentially the same thing. Okay? On the federal side, you also have a system. I've got some other slides that will help with that as well. You've got lower courts, and the highest court is the United States Supreme Court. Okay? An interesting question. Which court system is going to take your case? You know, they actually have a full semester-long course in law school that looks into something happened. Well, where are you going to bring the lawsuit? State or federal? A whole semester course on that issue. Don't worry about it. Those of you guys who are going to become attorneys someday, you can look into it then. But otherwise, if you go like with a lawsuit or some issue and you go to talk to an attorney and they're like da 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 da, and they're probably not going to talk too much to you about whether or not the case needs to be filed in federal court or in state court, but those issues get sorted out. Sometimes you end up facing them in both. Like if you do a crime, could you be charged with a crime under federal law as well as state law? Could be. Yeah. So that is a kind of a jurisdictional question. Yeah, go ahead. I'll answer it this way. You ready? Federal has a series of felony crimes as well as misdemeanor crimes. State also has felony crimes and misdemeanor crimes. Which one's more serious, felony or misdemeanor? Felony, very good. Okay, do you want a trick? A trick? Someday maybe you're going to be doing jury duty. If you're doing jury duty, remember what I told you about that felony DUI case? Right, with the postal worker? Right? And we couldn't tell the jury ahead of time, yeah, this guy has had 2 convictions already. Why couldn't we tell the jury that he already had 2 convictions? That's not fair, is it? No. I mean, the fact that he has 2 convictions is fine. Let's say one day you're 18 or older, you get called in for jury duty. And there you are sitting, listening to testimony on whether or not somebody was driving under the influence of alcohol. Right? And you're like, wow, this is just like what Mr. Hansen told me that one day in class. I'm sitting here, and I'm going to be the determiner of fact, along with the rest of the jury members. How many jury members need to agree in order to have a verdict? All of them. Very good. A verdict of either guilty or not guilty. Otherwise, it's called a hung jury. Yeah, hung jury, as in mistrial. They could either do it over again or not do it. And trust me, on a hung jury, the prosecutor will want to ask the jury members, so, I know that you guys didn't all agree for not guilty or guilty. Raise your hands if you agreed for guilty. Raise your hand if you agreed for not guilty. And you're like, you just make something up now. I mean, it's okay. If most of them were like guilty, then I'm thinking, okay, I'm going to win this thing the next time because it's just 1 or 2 holdouts. But if most of them came back not guilty, I'm like, I think we probably ought to let this thing go or try to get them to plead to a lower charge that's not as serious. Because otherwise, if they find not guilty, how much punishment can you give somebody who's been found not guilty? None. What did O.J. Simpson get to do when he was found not guilty? Go home. He walked. Or he drove. I don't know. His Ford Bronco was like out in the parking lot or something waiting for him. Who knows? With a helicopter floating around. That's after the civil trial. Yes? Oh, okay. Yeah. Okay. Make sure, because it is being recorded. Okay, so watch the rest of it. So let's say you're sitting around, you've got a DUI trial and so forth. We'll hear you out. And watch this, because this is going to be at the story. Got to watch the video to get the rest of the story. You're looking around, and if you see that you're sitting among 12 jurors, and maybe there's an extra, an alternate, in case one of the jurors gets sick and can't participate the whole time. That's interesting. Well, you could be sitting with a group of 6 people altogether. Well, that's interesting. Do you know what the difference is between 12 people in a criminal case versus 6? 12 people are felony jury trials. 6 people is a misdemeanor jury trial. If you're among 6 people on a DUI trial, it's a DUI first time, maybe second time. But if they're doing a DUI with 12 jurors, what do you know for a fact? He or she has done it twice before. Is the court going to tell you that? Is the court going to tell you that this person has had at least 2 prior DUI convictions within the last 5 years? No, of course not, because then you would be thinking, oh, well, they might have done it, again this time. This person's got drunk too many times. How do you know that they've got 2 or more in the past 5 years? 12 people, because Mr. Hansen just taught you that, didn't he? Yeah, and so you probably got to keep it quiet, because if you're slip a note to the judge, Your Honor, I learned something in the 10th grade in Mr. Hansen's government class. He was a former prosecutor, and he told me if I remember a jury member in Idaho on a DUI case, and I look around and there's 12 of us, I know that's a felony case, and for a DUI, I know that person has had 2 more. I'm not supposed to know that, am I? But Your Honor, I'm not going to think whether they did or didn't, more likely on this particular occasion, just because they were guilty on 2 other previous occasions. Yes?
Is that just with DUI?
Yeah.
Or is that-
Yeah. Yeah.
Are you allowed to tell the other people?
What's that?
You can tell the other people?
I wouldn't. I mean, it's kind of like, no, it's kind of like, it's one of the things where, I mean, they'll ask you in the general thing, like, do you know the defendant personally? And you're like, yeah, he killed my dog when I was 5. I think we're going to remove you from the jury for cause, because, yeah, at the very least, I would do a peremptory challenge if I was the defendant, and I would go, bye-bye, see you later.
And what about closing the entire jury, like that out loud?
Yeah, of course. Yeah. So just yeah. Sorry, I poisoned it. So if you're I don't know, somebody in here the other day was like, what can you do to get out of jury? It's like, why would you want to? I don't know. So, why would you want to? All right, here we go. Idaho Supreme Court, top of the United States, the court system. Here is the federal court system, spelled out here. And I'm going to show you a map that's going to help out as well. District courts, and actually you can write this down as well. On the federal court system, you have magistrate district courts. I've actually got them spelled out here pretty well. You got federal versus state appellate courts. We got the U.S. Supreme Court, and we got the U.S. District Court for the lower courts in Idaho. So at the very bottom, you have 94 judicial districts in 50 states and territories. And within those districts, you have levels of district judge and magistrate judge. That's in the federal system, so that covers the entire country. And then they break it out to 12 regional courts, including the District of Columbia Circuit. These are called Circuit Courts of Appeal. This is for the federal side. Isn't this fun? In fact, take a look at this map. Look at this map here, all right? Because you're going to need to know this. You don't need to know the color, but you need to know which is the color that is associated with. If you've got a U.S. District Court case in the state of Idaho, let's say, I don't know, I need a perp. I need a volunteer to be a perp. Okay, you're the perp. All right, I give the charge. You were charged, United States of America is the plaintiff. You are the defendant. You are charged with violating criminal law by shooting a protected species under federal law, a bald eagle. And you're like, it's just a bird. You know, if it was just a bird and you shot it out of season and it wasn't a proper hunting sort of thing and so forth, that might be a state charge handled in the state courts. But because it's a federal law thing, right? Yeah, I mean, it's like, unless you want a different charge. You like that charge? You want behind what's door number 2?
No, I want it, because imagine how cool I would be for shooting a...
No, that's not cool. Raise your hand if you think it's cool for him to shoot a bald eagle. I mean, let the hair grow back. I mean, seriously. Good grief. They're already struggling with image issues already. So, here's the deal. Look at the map here. Here's the deal. The federal government, the United States of America, U.S. Attorney, has got the goods on you. They bring you to trial. You are found guilty by a jury trial in federal district court. You appeal. You say there was some wrong going on. The judge should have admitted this or not admitted that and so forth. You appeal up. Take a look. Raise your hand. Tell me, what numbered circuit court of appeal does he appeal up to? Write it down. Idaho's federal court, the U.S. District Court for Idaho, is in the 9th Circuit, along with some other small states, like Montana, Nevada, Alaska, Hawaii, oh my gosh, Washington, Oregon, California, oh my gosh. Write it down. The 9th Circuit Court of Appeals is the biggest of all the different circuit courts. Over the years, they've kind of divided them up into different parts. I want to say like the 11th. It used to have Florida, or it has Florida in it now, but that used to be part of the 5th. It had Texas and Florida. Those are 2 big states. So Congress decided to go ahead and split those up into a bit. Idaho is still part of this 9th Circuit Court of Appeals. Congress has looked at dividing up the 9th into 2 different parts. It's like, whatever. It's there, it's whatever. Sometimes people are like, the 9th Circuit Court of Appeals is too liberal.
We're Idaho.
No, I mean, it's like the decisions by the 9th Circuit Court of Appeals, critics would say it's too liberal. Like, well, I don't know, what do you mean? Well, the justices are too liberal. Okay, well, who cares whether or not the justices of any particular Circuit Court of Appeals are too liberal or too conservative or whatever. We'll get into the details of what that actually means. But what is the only court that you really care that much ultimately about? Very good, the U.S. Supreme Court. Because whatever decision the 9th Circuit Court of Appeals makes could be appealed up to the U.S. Circuit Court, the United States Supreme Court. You got that? That's not too hard. That's just sort of logistics stuff. Okay? There you go. The U.S. Supreme Court. That is an interior shot looking from the back of the room. There are 9 seats. There are 4 pillars. There are 2 flags. There's some rooms in there for people to watch. They have only fairly recently added cameras to record the proceedings. And part of that was like a COVID thing. Because previously they let the public in. You get sketch artists. You get reporters who were writing things and so forth. I think they allowed it. The first thing they allowed was like recording devices, like for Audible. And then they started during COVID, because you couldn't have as many people coming in there. Then they started opening it up a bit. But it's very, very closed, quiet sort of a thing. And again, after they hear the oral arguments and they read the briefs and so forth, what happens next? They go back behind the closed doors and they talk amongst themselves. And it's literally like this, right? My justice, he had come to me and said, okay, so we just got this case. And it looks like 2 of these justices are like over there. They want to decide it this way. And he wants it to be decided this way. In order to have it decided his way, he needs to persuade how many people to join him out of 5? This was on the Idaho Supreme Court. 2 more. A total of 3, yeah. And so I would talk to him and they're like, okay, well, this is tough. Let's write it up this way. Let's write the proposed decision this way. Because if they vote and they agree to this proposed decision, then you got to write the decision, and your decision is the law. 3 of you. As opposed to the losers who are on the other side. Does that make sense? Let's get into a little bit more specifics on that. It's called majority, concurring, and dissenting opinions. Oh my gosh. And I'll use it in the context of the United States Supreme Court. Because you could have the law of the land is the opinion of one person agreed to by 4 other people. That makes 5. And then 4 other people disagree with them. And then who cares what everybody else in the entire United States thinks? Because they're not on the Supreme Court. Their views are not counted. You understand that? So after the oral arguments and so forth, and they go back into the room and they discuss it and they write potential opinions, I mean, there is a lot. Oh my gosh, you think there's politics in the real world? There is, but that's all out in the public. The politics that goes on behind closed doors with the Supreme Court is a very real thing. And these are people that are going to be working with each other for many, many, many years. And sometimes it's actually kind of nice because sometimes they disagree a lot, but they're actually very agreeable. 2 of the justices on the Supreme Court in recent times, I mean, one of them was very conservative. His name was Antonin Scalia. Another was very liberal. Her name was Ruth Bader Ginsburg. They both died on the Supreme Court and had their appointments replaced. But they liked each other. It's a good example where you can agree to disagree on political, judicial issues and still be friends. I mean, they liked opera. They liked good food. They liked jokes. They liked, sharing stuff. How many of you guys have a good, positive relationship with somebody that really is completely wrong on political issues if you were to be asked? Okay, there you go. That's nice. Okay? Yay, America! There's future. Yeah. I mean, I guess, and I put it in the most positive terms because it's like you like them even though you're just scratching your head. I just have no idea why they think that way on whatever thing, but they're so much fun, And maybe you avoid talking about politics sometimes when you want to have fun. Because all of a sudden, if you're like, hey, how about that Biden-Trump race? You're like, It's like, yeah, let's skip over that. All right, so here's the deal. Majority, write this down. Whoever writes the decision, the opinion, that receives the majority of the votes on the Supreme Court, that is the law of the case. That's the one that matters. You're like, well, is that the only thing that should be, who cares about the other ones? Well, you know what? We do care. The majority opinion we care about a lot because it's the law of the case. That's what we're going to be looking at as we go through these civil rights cases. But sometimes, let's get to concurring. Sometimes you're going to have some justices that will look and go, I agree with the results of the decision, but I would arrive at it differently. So what? Well, you know what? So what? It could make all the difference. Because the reasons that those other people give might ultimately be the majority reasons for later on. I don't know if that kind of makes sense. But it's not simple as like in Congress or whatever, yes or no. President, this person or that person. Supreme Court, well, I don't know. Let me see how you write it up. I remember there was one case with my justice, and he was like, I'm sure this other guy is going to take it over, but I'm going to sign it to me. And I said, you know what? Let's write it in such a way that even though you don't want to, you're going to agree to have the law changed, but you're going to change it in such a way that you still have control over it because you're the one writing it. And he's like, that's a good idea. Move a little bit. Instead of, if you can't beat them, take them over. You understand? If you can't beat them, join them and become the leader and direct it in the way that you want. Sounds kind of sneaky. Would people do that? Yes, it happens all the time. Yes, of course, yes. Okay? Huh? Yeah, it's like, yeah. Well, it's kind of like here. Donald Trump wanted to be run for president once upon a time. He could have run as an independent. Probably would have lost. But he's like, you know what? Republican, Democrat, I'm going to run as a Republican. If I get the Republican nomination, I'm going to have a heck of a lot of authority and prestige and position within the Republican Party. And if you ask him, it's like, well, what about the Republican Party? He's like, that's my party. And could he take a portion of the Republican Party with him? Yeah. I mean, that's kind of how it is. If you're very important and you join an organization and you take over the leadership of it, there you go. So these sorts of things happen. Oh, dissenting opinion, write that down. The losers. Why bother write a dissenting opinion? Well, you know what? Write the dissenting opinion. Say, the majority wins on this, but they're wrong here and here and here, and someday my voice will be heard, and my voice will be rallied around, and my voice will be the majority opinion. Good luck with that, but it might happen. It's worth writing down dissenting opinions. Because someday maybe a different membership or a different way of looking at it, the Supreme Court could come up with something different. And on the issue of like abortion, for example, some of those dissenting opinions that have been written over the last 20, 30 years could be the basis, maybe, for majority opinions heading in a different direction. Okay?